Right, so let's begin. As I said, my name is EMANUEL WEISGRAS. My presentation today is about confidentiality in translation. And I will try to address some of our legal and ethical obligations and some pitfalls. And at the recommendation of a friend, I'm also going to try to talk a little bit about another hidden danger that we don't really probably think about very much, but cloud storage. And just to get a feel for the interest on that topic. How many people here use cloud storage? Who here does not use cloud storage? Who here has no idea what cloud storage is? Okay. All right. So let's begin. This, as I said, this is on confidentiality, and I've also been asked to point out that this will be presented in English, and it is a general level presentation. All right, so as translators or language service professionals, especially those of us that deal with specialty fields, law, medicine, anything that might have any kind of secrecy, personal, governmental, or otherwise, we come across these issues and obligations. What I hope to do in the time that's allotted is to just review some of our legal, contractual, and ethical obligations. My background, as I'll discuss in a minute, because of my background, I'm focusing mostly on US, UK, and Israeli law. And as I said, some of the other things I'm going to look to cover, it may be a little fast because this was a more dense presentation than I suspected when I sent in my abstract. But I'm going to look to talk about some common pitfalls, some of which I'm sure you are all aware of them, machine translation, free email accounts, peer support platforms, and things like that, and how we can deal with them and address these issues. All right, quick introduction who I am. Like I said, my name is EMANUEL. I am a recovering attorney. I apparently like to switch jobs a lot. I am a graduate of the Benjamin Cardozo School of Law. Before that, I got a degree in history from New York University. In my lifetime, I have worked for many entities. They have included the New York County District Attorney's Office, the New York City Police Department, New York City Fire Department, a few law offices, and I am now the owner of my own boutique language service agency called WEISGRAS International Translations. Anybody want to guess how I came up with that name? All right, recovering attorney or not, I must give you a quick disclaimer and start my clock to make sure I don't run over. And that is this. All of these materials have been prepared for general informational purposes only. The information that I am presenting during this session is not legal advice. Do not act on it as such, and it may not be current, is subject to change without notice. And to kind of summarize what's written at the bottom, I am not your lawyer. So if you have any questions, ask a lawyer. All right. All joking aside, I will point out, and as may be obvious during this presentation, is this. Many of us live and work in different jurisdictions. I myself travel back and forth between several of them. We have clientele in this modern age, digital age that can span the globe. So when in doubt, talk to attorneys that can look into and research and find out what your obligations are, where you work, and where you provide your services. That being said, no discussion on confidentiality, I think, can begin without actually understanding what confidentiality is. So I'm presenting you with two different, not so different definitions. One comes from the Black's Law Dictionary, which is the essential law dictionary for US-based attorneys. And as you can see, they define confidentiality as secrecy, the state of having the dissemination of certain information restricted. A more common lay definition is from the Oxford English Dictionary, is the state of keeping or being kept secret or private. And related terms that are often interchangeable are secret and privileged. All right, so why is confidentiality important? Information has value. It may be monetary value, it may be governmental value, intelligence value, personal value. And as translators and interpreters, our end clients, be they individuals, corporations, language service providers that I'm going to refer to after this as LSPs, will often disclose confidential or secret information to us. Sometimes this will be done directly, sometimes this will be through third-party information. Oftentimes, and I think we've all seen people that are guilty of this, they won't stop first to define or even ascertain what our confidentiality obligations are, whether they are ethical, contractual, legal. So what I hope you get out of this is start to think about how we can, what we should, and what we do to handle these situations. So reasons that confidentiality is important is, one, protect private personal information. Those of us who work, like I said, in certain industries, for example, the medical industry, this is particularly relevant, private medical information. Commercial and trade secrets. Just by a show of hands, how many people here are translators as opposed to interpreters? How many of you have institutional clients? Okay, so a lot of you I see are translators, and about a handful of you, about 6 or 7 of you, have institutional clients. Right, direct. When the well, actually, the end client. When the end client, whether it's an agency or, well, not the agency. The agency is obviously not the end client, usually. But the point is, when you come across commercial and trade secrets, these are things that have economic value to their owners. Criminal investigations. Is there anybody here who works in that sector, in criminal law? All right, so you know that if you're working with a police investigator, or if you happen to be, say, a grand jury interpreter, you have legal confidentiality obligations. Other governmental sectors, such as anybody who works as, say, a translator for the FBI or the CIA. These are things that affect national security interests. Some of the things that are protected by confidentiality. Essentially, any non-public material that is provided to us by the client. This is material that the general public does not have access to. This may include source material that we've been asked to translate, such as documents, to transcribe, such as recordings, conversations, correspondence that we may have with a client can be confidential. Support materials that are provided may be confidential. For those of you that, say, work in the medical or biotechnical industry, you may receive other underlying documentation to understand that's also confidential. Other translated material, translation memories for those that work with CAT tools. And the thing is that there are risks of breaches to this confidentiality everywhere. These risks are things that we may not think about on a daily level. We'll discuss them. They will reappear as we talk. But they will include things like, how many of you are using hotel Wi-Fi today? How many of you are sending emails on hotel Wi-Fi? Does anybody know what the encryption is on that Wi-Fi? Right. Something to think about. We'll talk about it a little more, but they include other places that we can work, a cafe, a library, shared workspaces such as WeWork. All right. Who owes the duty, and to whom is the duty owed? Some of this may seem very obvious, but we probably don't stop and think about this too much. So the duty may be owed, or is likely owed, to language service providers if we're working for an agency. It's owed by, I apologize, the language service providers, the translators or interpreters, and any subcontractors that they use. The duty is owed to essentially the client and anybody up the line. That can be the same LSP. The outsourcing linguist. How many of you do favors, quote unquote, for friends? We've all done that, right? So do you owe that person a duty of confidentiality? And ultimately the end client. All right. Alongside that, in parallel, there's also who's responsible for maintaining confidentiality? Who bears liability when something goes wrong? Is it the agency, a freelancer, a subcontractor, a client? And where do these obligations come from? What's the applicable law? Is there a non-disclosure agreement? Are there secondary obligations if you're hired or contracted by a law firm, a hospital? How do you store your client's material? Are there statutory requirements of which you need to be aware? So let us discuss a little bit the sources of these obligations. There are essentially 4, or I'll call them 3.5 sources, because one, I'm guessing most of us do not come into contact with on a daily basis. Laws and statutes are an obvious source of this obligation. Codes of ethics. How many of you are aware that the ATA has a code of ethics? Okay, a little more than half of you. That's good. That's very good. As a matter of fact, almost every professional translation and linguist organization does have a code of ethics that deals with confidentiality. Local and international standards. I'm not going to get into this because this is not something that's going to affect most of us, if any of us, directly. But the International Organization for Standardization does have certain ISOs, international standards, which require confidentiality and data protection and security. And of course, the other obvious one, contracts and agreements. And these include subcontracting agreements, non-disclosure agreements. All right, so I'm not going to read these word for word, but I'm going to give some examples of legal and statutory sources for secrecy requirements. Anybody want to throw out a guess of what one might be that's relevant locally, meaning in the United States? HIPAA, right. That's actually the second one that I put up. Probably should have been the first. The first one that I put up is the U.S. Espionage Act of 1917. Probably doesn't affect most people here, but I am going to read one part of it simply because you should be aware that this kind of statutory language exists. So subsection F of section 793 of 18 U.S.C. says, whoever being entrusted with or having lawful possession or control of any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument. Is this starting to sound like an NDA any of you have ever read? Anyway, jumping down to subsection 1 in that same paragraph, through gross negligence permits the same to be removed from its proper place or custody or delivered to anyone in violation of his trust or to be lost, stolen, abstracted, or destroyed, or having knowledge that the same has been illegally removed from its proper place of custody or delivered to anyone in violation of its trust or lost, stolen, abstracted, or destroyed, and fails to make prompt report of such loss, theft, abstraction, or destruction to a superior officer, shall be fined under this title or imprisoned not more than 10 years or both. Think about that. That's deep, and that's harsh. Gross negligence. That means you went to a cafe, you left your computer open, somebody read something, you just committed a federal crime. You can go to prison for 10 years. That's terrible. There are consequences that we must be aware of. And of course, as somebody said, one that's probably a lot more directly relevant to most of us, HIPAA. We can summarize HIPAA by saying, what are we not allowed to tell? Anything. When in doubt, nothing. Say nothing. And I mean, it seems kind of obvious, but these are things that are private. You can hurt a person by disclosing this information. This is not arbitrary and capricious. All right. For those of you that are from Europe, there's, for example, the UK Official Secrets Act. Even my eyes are not that good, so. And this one I put up there, not because it's directly relevant to anybody in this room other than perhaps me, but because there may be local legislation wherever you practice that may mirror something, all or part of this. The Israel Privacy Protection Law of 1981 actually protects pretty much any personal information. It doesn't matter whether you receive it in a professional capacity or in a personal capacity. If you divulge it without permission, unlawfully, you've just committed a tortious act. You've something for which you can be sued, either civilly or even there may even be criminal sanctions. All right. Confidentiality in our professional codes of conduct. Anybody here not an ATA member? No? One. Okay. That's not bad. Only one out of 3 of you. Great. I jest for anybody listening to this recording. There are 5 people here, not 3. All right. So most of us are members of at least one professional organization, the American Translators Association, the Israel Translators Association, was it FIT? Right. I'm sorry? Oh, okay. And as I mentioned earlier, most, if not all, of these have professional ethical codes of conduct to which we are subject. And I'm told, or I've read, that they're actually expected to have more bite than in previous years if you actually violate them. So, most relevant to us right here is the ATA's Code of Ethics and Professional Practice, Section 2. We commit to holding in confidence any privileged or confidential information entrusted to us in the course of our work. That can be pretty much everything. The Chartered Institute of Linguists has similar language in their Code of Conduct, including the obligation to take reasonable precautions to keep information and material confidential, including when it's subcontracted, and not to use that information. But does anybody do you realize, by the way, that a lot of times this obligation not to disclose also involves an obligation not to take unfair advantage of information with which we're entrusted? Okay, I see heads nodding. So I mean, it may seem obvious, but it may seem just as obvious if somebody gives you a piece of, say, insider trading information. Well, you know, I don't work for the company. Well, but you're subcontracted indirectly or directly, maybe you do. What are your obligations? These are things you should always think about. The Israel Translators Association Code of Ethics also says, I will safeguard the interests of my clients as my own and divulge no obviously confidential information, and am aware that clients may condition my work on the signing of an NDA. And everybody knows that's a non-disclosure agreement, right? Right. The Institute of Translation and Interpreting also has similar language. I'll spare you reading it. But for the most part, I think most of us are aware of our obligation to maintain confidentiality based on non-disclosure agreements. And as I just wrote up here, I included this not because this really has anything to do with confidentiality, only because it's a pet peeve of mine when I see NDAs that are forwarded to me by other LSPs. They like to include this non-compete requirement. It's under the same caption, and they're not the same. I mean, it seems obvious. One is not to disclose information. One is not to ever work with anybody else ever again. And I say that tongue-in-cheek, but one of the reasons I bring this up is because here's a situation that I just want us all to think about, and if you want, by show of hands, tell me how many of you have done this or know of somebody else who may have done this. You receive an inquiry from a client. Well, before we work with you, we need you to sign an NDA. Sure, no problem, right? They send you the NDA. What do you do with it next? You print it out, you put in your name, you sign it, you send it back, right? What was that? I heard somebody say, read it. Seriously, read what you're signing. It is so important because sometimes some of these non-disclosure agreements have ridiculous, ridiculous clauses. A lot of these clauses are even unconscionable, and you're committing to this. And while you may have other reasons why you need to violate this in the future, you'll still have a contractual obligation, which can be acted upon in court. All right. So there are two kinds of NDAs that I assume most of us in this room will have come across. Most obvious are the client NDAs that will be forwarded to us. But how many of you have your own NDAs that you forward to subcontractors? I see about 5 hands. Non-judgmentally, I'll say, shame on you. Shame on you. How many, again, this show of hands, how many of you have outsourced work to friends? Okay. Outsourced work to friends. If you have outsourced work to a friend, I don't care how close that friend is. When I say outsource, if anybody doesn't know what I mean you've gotten a project that you cannot handle if you're an individual contractor, or if you're an LSP, well, then you're really nuts if you're not using an NDA. But if you have given a friend a project to handle because you couldn't, and you do not have an NDA with that person, you might have just been negligent, professionally negligent. You should, even if it's a very good friend, have a simple NDA that at the very least, and this will appear on a later slide, but I'll say it now, it should cover at the very least the same confidentiality obligations that you have undertaken yourself towards your end client. So those are the subcontractor NDAs that I mean, and they're easy. You can probably find something online. You can probably mirror the language from the NDAs that you've received. Oh, it's actually on this slide, great. But it needs to at least be as comprehensive, but not draconian, as the NDA that you've signed for your end client. So on mirroring the NDA, are you doing something So the question was, by mirroring this NDA, are you yourself doing something wrong? When you say that, do you mean, are you?
Word by word, but okay, I take this, my friend signs it and say just.
All right, so the question is if you copy the NDA word by word so that it's, and have your outsourcee, your subcontractor sign it, have you done anything wrong? So long as the NDA itself is not illegal, unconscionable, or immoral, then no. I mean, there's arguably, you could say there's arguably an intellectual property issue of whether the language. This is one of those things where I would say, I imagine your client is probably more concerned with you're protecting their confidentiality than a particular clause in a one-page document. Hopefully one-page document. Yes, that is my attempt at humor. Okay, so what are the things that are appropriate for a non-disclosure agreement that you have, that you either sign or have somebody else sign? Obviously, keep my information secret. Other things that are legitimate, but you need to be aware of what the requirements are data security requirements, which include how are you storing this information. A lot of these NDAs have this odd clause, which I think entire sessions have actually been put together to address. What do you do when that clause says, after you finish the project, you must destroy this information within 2 weeks? What do you do? I mean, I don't have an answer to that, by the way. I think it would take more than an hour because there are too many variables. But the point that I do want you to take away from this here is be aware. If that clause is there, be aware of it. What are you committing to? What happens if you don't actually follow through on your commitment? Other things that should be in there are obviously non-disclosure of confidential client information unless authorized or required by law. Again, this may seem obvious, but nothing's obvious in contracts. Nothing. You need to make sure that there is an out clause for you over there. There's another one you may want to consider. If you're provided with material that, for whatever reason, ethical, moral, it needs to be disclosed. We'll get into it, I think, in a slide a little further down. Actually, the next slide. But there are other reasons that you may say, hey, I can't keep this secret. As we said, the obligation not to gain commercial benefit from information that you're provided. Along with the storage is the data security. And we'll talk about that at the last section. And trickle-down obligations. Are you permitted? You know, you had your friend take that project from you because you were overworked, but does your NDA say that you're allowed to give that to a third party? Some of them restrict them. What do? You know, are you going to tell your client, I actually have third parties? I always include that personally, obviously. Or do you pass this off as your own work, which I think is unethical for other reasons. Transparency up front is always best. Things that you should avoid in the NDA, as I said, are clauses that bind you to absolute secrecy. Obviously, if you're working for the government, that might be an exception. Anything illegal or unethical. I mean, if somebody's basically coming to you, I recently saw another attorney linguist who has a presentation on confidentiality, and she discussed a client who brought her stuff that I believe included money, evidence of their own money laundering. No, just stay away. Just don't. Draconian penalty clauses. I mean, yes, we need to be held responsible for things that we do wrong, for our negligence or other breaches or violations. But what's reasonable? What can you support? What can you reasonably be expected to do? And what penalty is reasonable if you somehow fail in that duty? There's no right or wrong answer. You need to. This is a very individual question. Everybody needs to ask themselves. But a draconian penalty clause is something like, if you divulge any of our secrets, we're entitled to liquidated damages of $1 million plus any real damages. No, that's crazy. But does anybody think that that's insane? It would never appear in an NDA? Nobody. Great. Other considerations are things we've discussed, which is if you're working for professionals who have an obligation or duty to maintain privilege, such as doctors, nurses, other healthcare professionals, attorneys. How is that addressed? Does that privilege extend to you? under local law, ethically, contractually. When is privilege no longer privileged? Well, first of all, and this should be, like I said, this should be in your NDAs, simply because even if the law requires you to disclose something, but your agreement says don't, you might have done the right thing under criminal law, but you may still be liable in contract and can still be sued. So make sure that any evidence of criminality can be disclosed. If there's a threat of imminent injury or death, you know, somebody is describing, let's take it to an extreme, a human trafficking ring. Are you not going to disclose that? Of course you're going to disclose that. And what happens if, you know, it's nothing quite as dramatic, but maybe there's potential evidence of tax fraud, and you get a court order. One moment, I see a hand just went up. I'm going to break the rule and take questions in the middle, that's fine. But what happens if you get, let's say you do financial documents, and next thing you know, the IRS serves you with a court order or some other quasi-judicial order saying you need to disclose and turn over everything that you just translated. What do you do? What are your obligations legally, contractually? Sorry, there was a hand up. Yes, ma'am.
Are these things that you include in your own NDA, or is it something that you are going to interject into your client's NDA? Because these are, mind you, we haven't seen the text yet.
Okay, so the question is this the kind of language that you would like to see in your end client's NDA, meaning the NDA that you yourself are signing, or in the NDAs that you're providing to your subcontractors? Am I correct? Is that your question? Because you, especially when you haven't seen the source material. So the answer to that is both. Both, because you want your NDA, especially when you, theoretically, you should not have seen the source material before you're signing the NDA. I mean, I think we all know that there are exceptions where you've gotten the file and you're like, sure, I'll do it. Great, sign an NDA first. What? I've already seen the material. I sent it to my friend. We already published it on Facebook. So yeah, so the answer to your question is yes. You should. This should be both. I mean, this works both ways. It's a two-way street. And these outs, I think, morally, you need to include in anything you're having somebody else sign, and you should not commit to anything that does not allow you to disclose information that you're required to disclose for whatever reason. How are we doing on time? We're doing really well. This is fabulous. All right. We may even get out early. Yay! All right, so what happens? We know there's confidential information whose release can prevent threat of death or injury. Does that seem really bizarre or will never happen to anybody in this room?
I'm sorry, but that basically happened in the Toyota.
Yes, yes. No, I hope nobody heard that, right? Okay, good. So, so this is really not theoretical. This is a real world situation, and most of them are not very dramatic. But, I mean, can we release this stuff without fear of repercussions? What happens? It's fine, right? I mean, nobody's ever going to do anything. There'll be no consequences. We did the right thing, right? Wrong. And indeed, as you just pointed out, this, as I call it, the curious case of BETSY Benjaminson. Does anybody not know who she is, or maybe not who she is personally, but her story? All right, I see a few people shaking their heads, hands half up. All right, so BETSY Benjaminson, an American expatriate who moved to Israel, a familiar story, right? Like yours truly. She contracted for a language service provider that won a contract to translate internal Toyota documents that related to litigation that was going on in the US. And I'm really not sure how their document triage went, but BETSY basically got to see everything. And this was exactly the time, for those of you that were not aware, there was several years ago, about a decade ago, and as far as I know it's been resolved, but then again, given this story, maybe not. Toyota Camrys, which is one of the more popular cars in the world, had a sudden acceleration problem. And they convincingly, through 60 Minutes reports and testing that was done after the fact, said, no, all of these accidents, these supposed sudden acceleration, were either user error or the shifting of a floor mat in the car, and they had a recall and they fixed the floor mats. Great, right? And then if I'm not mistaken, the Japanese royal family that owned a Camry also had an accident. And from the article that I read 3 weeks ago, which is linked in this slide if you look at it later, apparently she saw that and that was the last straw for her. And she said, that's it. I'm seeing this correspondence, I'm seeing this internal Toyota documentation, and they are risking people's lives. They know there's a problem and they're hiding the problem and they're not even fixing it, so I'm disclosing it. And what happened? Well, the good news is she was not sued. When the poop hit the air oscillator, this translation is a wonderful thing, then she was not ultimately sued. Toyota, of course, faced tremendous backlash because this came to light. She did, of course, retain attorneys. But ultimately, the price that she paid was that she lost more than half her business. As far as I was able to ascertain from just news stories, she was able to work for one more LSP after the fact, and then nobody would work with her again when they realized who she was. And you know, and I have to tell you, I stand up here as the owner of a small company and a translator, and I ask myself, would I hire her today? If I had a project for which she was otherwise qualified, would I hire her? On the one hand, I think what she did was noble. Not only noble, I think it was a moral imperative. I think I would have done the same thing. But I also think that I would have a lot of trouble hiring her because I know she breached her NDA. And think about that from your point of view, is if you work with somebody like that, or not your point of view personally necessarily, but a language service provider, you think this person is a noble, and I think she's a very noble person. I think she made a difficult decision. But what would have happened if I hired her today and she did it again? That's my liability because I hired a person who has a history. It cost her dearly. So the question is, what would you do? All right. How long do we keep secrets secret? And let me tell you the reason I asked this question. Last February, I participated in Tel Aviv in the Israel Translators Association conference, and afterward, a linguist approached me, said he'd like to work with me. It was in a language pair that I really don't have a whole lot of collaborators. And I said, great. I sent him a copy of our subcontracting agreement, which contains what kind of clause? Anybody want to guess? An NDA, correct. And the NDA just says you will never, ever divulge this stuff unless. And he said to me, well, I won't sign a clause that is not finite in time. There's no expiration date to this. I said, well, okay, well, then you tell me, what's the natural lifespan of a secret? I mean, is it 2 years? Is there like an FDA requirement? Help me figure this out. It's ridiculous. It's one thing to say on a non-compete, it's good for a year, it's good for 6 months, that's reasonable. But secrets are secrets until they're not. And you don't want to be the cause of that secret not being a secret anymore. Let somebody else do that. Let your client do that. Your clients will inevitably do that anyway. If it's a commercial client, there may be, what do they call it, corporate espionage. Don't let it be you. These secrets, we're morally, legally, and or contractually obligated to keep these secrets as long as they are not in the public domain. If the NDA specifies the duration of the confidentiality obligation, I think that's a little silly. I think it makes more sense to say upon release of a product and to the expiry of a patent, fine. But say for a year, that's, if that's what your client wants to do, that's fine. Please don't put those in your own NDAs. And don't be surprised if you ever ask me to put in an expiration date and I say no. All right, what happens, by the way, if stuff happens? You didn't mean to. You were in Starbucks, somebody looked over your shoulder, they saw that Toyota was going to go down, and they used that and sold all their Toyota stock, they shorted it, and somebody figured out that they got that from you, and somebody else sues you. How many people here have professional liability insurance? Ooh, that's really not enough hands. Again, it's another lecture, but liability insurance is unnecessary until it's not. And you don't want to be that one guy that said, oh, I should have gotten it. Got $1 million, by the way? No, okay. You should have, I personally strongly believe you should have professional liability insurance, indemnification insurance that should cover certain cases of breaches of confidentiality, especially not the malicious ones, but negligence, maybe not gross negligence, but mistakes happen. At the end of the day, we're still people. We try to do our jobs, we'll have a discussion, we'll bring our computer, we might lose our bag, and then stuff that was protected is no longer protected. Criminal liability.
How high do you go?
The question is, how high do you go? So again, that's a discussion for a different presentation, and it really depends on you. What is the scope of your business? What is an individual project worth? How much damage do you think you may reasonably be sued for? That's how high I think you should go. And luckily, we live, most of you at least live, in a country in the US where there are policies, it is a recognized issue, and it's not something you have to go scrounging around for and paying obnoxious amounts of money, I think. I see a hand.
What if it's not your error, but you got hacked?
Okay, so the question is, what if it's not your error, but you got hacked? So again, just looking at it strictly from why I think you should have liability insurance to cover this, that's exactly why you need it. Because what if it's not your error, but you got hacked? There will always be a claim that it was your responsibility to maintain the security of that data better, because that's what you committed to in your NDA. Or just because we have nobody else to sue and you're the easiest target. So it's not a question of whether it's your fault or not. It's a question of whether, if somebody else says it's your fault, what's going to cover you. Criminal liability, not a whole lot you can do other than hopefully your insurance policy will cover hiring Ben Brofman. For those of you who don't know, he's just a high-powered New York City criminal attorney who's really good. Not that I've ever seen him in court against me or anything like that. Professional censure. You don't want to be the guy or the girl that got booted out of the ATA, the ITA, or ITI, or because you were sloppy with secrets. And as we saw in the case of BETSY Benjaminson, loss of revenue, this is your livelihood. If you become known as the person that doesn't keep secrets, you're going to lose your ability to make money. All right, I'm going to start moving a little faster. What's not protected by confidentiality? This also usually appears, or should appear in an NDA or any agreement, because if it's not a secret, then there's no reason to keep it a secret. If it's in the public domain, and does anybody not know what I mean when I say it's in the public domain? When it's in the public domain, meaning there's general access to it. It's not something that's really reasonably considered a secret because you can find it with doing a reasonable search like Google. Anything that enters the public domain after we've received it, that really should not be our responsibility to maintain anymore either. Hidden dangers. This is the stuff that we really don't think about, and this is maybe the most important part of what I'm going to tell you today. Everybody still hear me all right, by the way? Great. Again, if any of this stuff seems obvious to you, great. If it's not, start thinking about it. We all like to, well, maybe not all, but most of us like to whine and moan about machine translation, the evils of machine translation, what it has done to the profession. But is there anybody here who can honestly say that they never, ever use machine translation? Never, ever. Not even so there are 6 hands that have gone up. So do you all get up and go to the dictionary? I bow to all of you, really. I'm lazy. If there's a word that my brain, sometimes I don't want to use the common term because this is being recorded, but my brain just doesn't want to go there and remind me what that word is. I've done it. I've gone to Google. I won't put an entire phrase in, but I think the majority of us have used it for a quick fix for a word, a quick turn of phrase that we just needed inspiration. Not cheating, just inspiration. How many of you use CAT tools? And for those of you that don't know what a CAT tool is, CAT is computer-assisted translation. It is not machine translation. It is a program that learns from your translation and remembers translations that you have already done. Okay, I see a few hands. I see a lot of hands, great. I too am a convert to CAT tools. A lot of them, maybe most of them, have machine translation plugins. Now, it's one thing to say, it's 2 in the morning. I've had 5 glasses of wine, and I probably shouldn't be translating right now. And I don't remember how to say hello in any other language. So I turned to Google Translate. It's one thing. But when you're using it in a CAT tool, the problem is that these plugins will automatically populate the various segments of your document. And you're saying, okay, but what's the big deal? It's machine translation, right? I mean, so the quality is not so great, right? No, it's far worse. And the next slide, in fact, you know what? I'm going to jump ahead and then jump back. For those of you, I pick on Google. Why? Because they're huge and they're easy, and I've done work for them. And something to think about, by the way, is I have done work for them where they have required that I not store their documents in any cloud server. I mean, there's so much irony here. Google came to a human translator for confidential documents that said not to store it in any cloud server. I literally had to keep it on one standalone USB drive. And so maybe the reason for this is how many of you have ever stopped and read Google's privacy and terms and conditions? Okay, so out of like 7 people in this room, 3, oh no. It's pretty bad. And this extends to both Google Translate, Gmail. I know there are others that have lectured on the use of Gmail and whether we think it's professional or not, but this is another consideration that you should keep in mind when you're using Google Drive, at least the free version, and Google Translate. So I'm going to read to you. Some of our services allow you to upload, submit, store, send, or receive content. You retain ownership of any intellectual property rights that you hold in that content. In short, what belongs to you stays yours. Sounds good, right? Until you get to the next paragraph. When you upload, submit, store, send, or receive content to or through our services, you give Google and those we work with. And do you know who Google works with, by the way? The whole world. A worldwide license to use, host, store, reproduce, modify, create derivative works, just as those resulting from translations, adaptations, or other changes we make so that your content works better with our services. I mean, you can read the rest of that if you want, but there's also an issue, for those of you that know or don't know how machine translation works, is it learns from what we enter into it. So, while not necessarily highly likely, something you put into Google Translate next week might show up on somebody else's translation in reverse the following week. And there's not a whole lot of in between. So if there was something that was confidential and you approved the translation and somebody puts in a close reverse of that, theoretically that might show up in another language translation. And you just breached confidence. I see a hand in the back. Yes?
You said the free version of Google Drive?
I said the free, yes, I did say the free version of Google Drive. There are, I will tell you, a not so big secret. My email services are through Google. Google offers something called the G Suite. It used to be called Google Apps for Business. It's an easy way for you to have your own email and domain. And the terms and conditions, the privacy policies are different. They're much different. And so that is theoretically again, more secure. What they actually do behind closed doors, we don't know. And it'll be interesting to see, as a quick aside, what happens next year when certain European regulations take effect, which affect the collection and storage of data, any data, where the penalties can range in the millions of euros. So let's see what happens and how Google fights that one. All right, common faux pas that we have seen or have committed. Oh, that's right, thank you. Okay, other things to keep in mind that we may have used, and I'm not here to tell you don't use them, I use these. They're very good. Just be careful what you put into them. You should never put in anything identifiable and confidential. But forms that are commonly used. How many people here are familiar with or use pros.com? A lot of people, all right. You know the kudos, questions, and answers, right? Limit it to the part you don't know. I realize context can be important. If you're going to put in something that's contextually relevant, modify it so nothing identifiable is in there that will ever come back to you. Be as narrow as possible. other similar media, Facebook groups, professional listservs. And anybody know how to translate biodegradable, that kind of thing? Careful what you put up there. And then, as we said, the shared cloud workspaces, such as those of us that collaborate on Google Docs, Google Sheets. Yes, I see a hand.
It's interesting that if you set up an account with Microsoft, it automatically sets you up with OneDrive.
Yes, just like,
By default, so you do have to deactivate that. Otherwise, any document on your computer, any picture, anything, it automatically goes to OneDrive.
okay, so that's an excellent point. So I'll just repeat what was your name?
Danielle.
What Danielle said. When you have a Microsoft account, Microsoft automatically sets you up with OneDrive. It's not just setting up a Microsoft account. It can be as simple as installing Microsoft products and using Windows. They ask you to open an account, and suddenly you go to save something in Word, and it's saving it in OneDrive automatically. You need to make sure that you're not accidentally saving stuff there that whose security you're worried about. Excellent point. Thank you, Danielle. You need to deactivate the default saving to OneDrive. All right, so one of the common faux pas that I love, when I say love, I mean it drives me out of my freaking mind, is I get emails. Quick step backward, I'm listed in the ATA directory as a translator, not an LSP. So I get emails about once a month from an LSP that I have never had any kind of interaction with saying, can you translate this document? Who are you? This is interesting. Honey, bye. Yes, call the broker, right. Why would you do that? You don't know me. Maybe it's not even my correct email address. And they've sent me this document, which is theoretically privileged. I'm sorry?
By the way, what languages do you
Yes, and by the way, what languages do you translate? I can barely speak English. Are you kidding me? Yeah, I mean, they send this stuff out to people who have never signed an NDA. Again, that to me is absolutely insane. All right, I'm going to move a little faster because we still have that whole data security and protection thing to talk about. Other things to keep in mind. Like I said, well, we've talked about whether your duty can present an ethical or legal dilemma. Make sure that you avoid those situations. You should have some kind of liability insurance because nothing is perfect. And consider where you work physically. It's very popular in the language professions, translators in particular, as opposed to interpreters. You work in a Starbucks, you work in a WeWork. Does anybody not know what WeWork is? This is not a plug for WeWork. But a WeWork is one of several chains that have developed these shared workspaces where you don't want to work at home because there are a lot of hidden dangers at working at home, like I did the laundry and not the translation. But the food was marvelous. So they have these, if you don't want to, I mean, renting an office, the phone, the electricity, the maintenance, the rent can be very prohibitive. What they've done, and they say, well, you'll pay us one fixed fee, $500 a month, whatever it is. I have no idea what they actually charge, but say $500 a month for like a 1 foot by 1 foot cubicle. Or more likely, they have these long desks where they have ports set up on the desk, kind of like going to the Apple store, as much noise and as much privacy. And they give you Ethernet or Wi-Fi access. You have a place to work, and you can just sit on your computer. The problem is that you went out and you invested. You're like, yeah, this is my workspace. I got my 47-inch monitor. And I'm going to start, translating this contract. Except that everybody, like 3 miles back can see what you're doing now. So be aware of the locations in which you work. Where if you're using the Wi-Fi, is it secure? That's critical. What is this security? Just because it's secure doesn't mean it's secure. And again, I'm not saying this to make you not use these places. I'm saying this because you need to be aware of what these places are and the dangers they pose. All right, data security protection, going to the cloud. For those of us, for those of you that don't know what I'm talking about, many, if not most of us, have gone over to cloud server storage. Especially when you have the convenience of something like, I personally use Dropbox, so Dropbox is my basic point of reference. It's great because I save stuff, and it's secure in the cloud, and it's also copied locally on any device on which I've installed Dropbox. That in itself is a danger, because do I control all of these devices? If I don't, that might be a confidentiality breach. So what are the issues with using cloud storage? And again, thank you, Jamie, for this brilliant idea. So Data Insider, a data guardian, digital guardian blog, as they call themselves, pointed to 6 major issues. I'm going to focus on the first 4, which are the ones that are really relevant to, I think, all of us individually. Problem number 1 is when you're using cloud storage, you're essentially giving your data, your documents, to somebody else to hold on to. They make all these great commitments, but at the end of the day, you're giving it to somebody else. And how you transfer it to them is also critical. What kind of security do they have in place? How is it getting there? Keep in mind, you want security that encrypts your files, both during storage as well as transit. At the very least, this is basic bottom, minimums. You want at least 128 to 256-bit encryption. Doesn't matter what that actually means, just make sure you have it. Data leakage. It's a multi-user environment. You're not the only ones using Dropbox or Google Drive or OneDrive or what are some of the other ones out there? Anybody know? And there's third-party services, plugins. All of this risks your data being viewed or mishandled. You should know who your provider is, what they're committed to, and what experience has shown their actual practices to be. Use strong passwords. Don't just depend on the security provided by the data storage provider. This is a theme that comes up all the time, by the way. What you yourself do is at least as important, if not more important, than the service that you choose to use. And the first step there is use a strong password. Always is use a password. Another thing that's very relevant in our business is they're subject to this whole bring your own device phenomenon. I mean, how many people here work on their employers' laptops or computers? A handful out of all of you. How many of you are able to access data that you work on, files, whatever that may be, using your own devices, smartphones, laptops, home computers? 6 of you, that's it? None of you can access your client's files with your own devices? I think almost all of us can access these files with our own devices, right? I mean, that's the nature of our business. We get stuff from LSPs. Even if we're using, for example, I know Morningside, I believe, is transferring to everybody using MemoQ, right, through their servers. But you're still using your own computer. And so their security is only as good as the computer you're using. Snooping. According to the Data Insider, files in the cloud are among the most susceptible to being hacked without security measures in place. The way they're stored, the way they're transmitted, the way we handle them ourselves, all put these files at risk. Again, you want to make sure that you're using a service that is encrypted. You also want to make sure that you yourself are doing what you can on your end, especially on more sensitive files, to protect them. Key management and cloud credentials are really, if you have an organization where there's somebody who's in charge of information technology and security policy, this is for them, not so much for us. What we should take away from this is this. In addition to the 6 issues that they mentioned, we need to remember that nothing is perfect. None of the commercial cloud storage providers rather are perfect. They themselves, they may claim, again, Dropbox being my point of reference, claims that their security protocols are some of the strongest in the industry. Then comes Edward Snowden and says, no, they're not. And that's a man I would trust on that, actually, if nothing else. Their interests are commercial. They are going to provide as much security as they can while catering to their own commercial needs. So if it doesn't suit them at the end of the day to provide what we consider enough security, they're going to go with what's most cost effective to them. Another thing just to keep in mind is that these services can be subject to denial of service, DOS attacks. And if you use cloud, if you depend on your data in the cloud, and that particular provider is subject to a denial of service attack, you will not have access to that data. You may want to keep a local copy of your, excuse me, your important files. I won't read which ones, but the Cloud Storage Boss blog named the 3 most secure data storage providers as of January 2017. But what you should, the things to keep in mind when using cloud storage is 1, be aware of your provider's security features. What level of encryption does it use? Frankly, you should not be using anything less than 256-bit. Use secure passwords that you change frequently, just like with your ATM card. Your online password should be at least 16 characters. They should contain mixes of numbers, symbols, and upper and lowercase letters so that you're guaranteed to forget it by tomorrow. Now there's a new trend which I'm actually very fond of, which is to use two-step verification, which basically says, my bank uses it, for example. I need to log on, I put in a password and a random username, and then they send me on a device that they know I own, in this case my cell phone, they send me a code. And I need to input that random generated code every time I need to access. So if you can find a server that allows you to do that, that will obviously be far more secure than something that allows you to simply save and download. Make sure your physical device is secure. If you're using Dropbox and you have the app installed on your laptop, and your laptop is not secure, then you've done nothing, especially if you're using your computer in public and you just got up to go to the bathroom and then have lunch and never locked your laptop. If you're dealing with stuff that is that sensitive but not at the government level, consider using third-party applications such as Boxcryptor. It's a commercial application. It is compatible with a lot of cloud storage providers, and it will further encrypt your data so that even if somebody at Dropbox says, I want to go into Eve's folders and see what cool stuff she's been working on, it doesn't matter because it's further encrypted, so they can only undo their own encryption theoretically. Password protect stuff. Windows Word allows you to password protect most files. Final thoughts. Remember, everybody's obligations will differ in scope and severity. Be aware of what yours are. What are the pitfalls that you face? Just morally and ethically, keep your stuff secure. Keep your client stuff secure. It's also, I think, sound commercial advice. Your individual devices, your security is only as good as your weakest device. So your mobile device security or your laptop or your home computer that your kids may have access to, think about how you're securing your information. And make sure you use secure passwords, Wi-Fi networks, etc. And on that, we have an entire minute and a half for questions. Okay, I'm sorry. The first hand, I think, was over there. Yes.
If you, as a translation company, to get that material, let's say from Toyota, and you do not contact the authorities, could you not be accused of aiding and abetting?
So the question was relating to the Toyota case, if the language service provider themselves did not receive such information and did not contact the authorities, could they be held liable? I actually don't want to answer that question because it's a complex legal question. The answer is theoretically yes, probably no, but it's not quite as simple as that. If somebody were to get hurt and you could show malice, there might be an argument to be made, but I will use 10 seconds of the time we have left to just tell you a quick joke about why there's no easy answer. Two lawyers are walking together and one says to the other, you know, we have a problem, your dog bit my daughter. And the other one says, oh, you know, well, let's sign a contract and settle this out of court right now, $50,000. Great, they sign, they transfer the money, the next day they're doing this again, and the other one says, why did you ever sign that contract and give me the money? I mean, you don't have a dog and I don't have a daughter. And the other one says, yeah, but I mean, you never know what the jury's gonna do. So there's no really easy answer to that. I mean, it's malleable. Next question. I have to pick on somebody else, I'm sorry. In the back, and then you.
Very quickly, in follow-up to these early lady Benjamins, how did she actually breach her NDA if her justification for disclosing this was saving somebody's life?
So the question is, again, with the Benjaminson case in Toyota, how did she breach her obligations if this breach theoretically potentially saved people's lives? So I mean, the problem is we don't know what her NDA stated. It was probably never disclosed. There was no court order. There was no evidence of criminality, arguably. And so she basically decided that it was morally and ethically incorrect what they were doing, and so she breached her own moral and ethical obligation by disclosing this information. I'm sorry.
Thank you for a wonderful presentation.
You're welcome.
What you said today will probably be obsolete or need revising tomorrow. How do we track this? Is the ATA doing anything? Would it be a good idea to have a working group or something?
So 3 questions. Was one, well, one was a point. Was this will probably all be obsolete tomorrow. This is true. This is an ever-evolving topic. And in truth, I learned tremendous amounts just doing the research to put this together, which is why I'm running over right now. We'll get yelled at afterward. And whether the ATA is tracking this, I don't know that they are, and I don't know that they're not. I mean, these presentations basically are, we present abstracts on things that we think are relevant, and the ATA looks at what's available each year. But certainly this is something that we can all individually even write about in the ATA Chronicle, I believe, and follow these things and take an interest and even suggest more best practices. Sorry, there was somebody in the back who was patiently holding up their hand and is no longer. Sorry.
Windows 365 is going to become cloud. What's your take on that?
Windows 365 is going to become cloud, and actually to some degree has. I don't know. Honestly, I don't want to comment on something that I have not researched. I would certainly, but when looking at it, I would look at what are their terms and conditions, what are their security protocols, and what are their protections, and make your own decision. Yeah, okay, you've really been patient.
No, first, one quick comment regarding the Israeli, similar situations of breaching the NDA for, saving people's lives or, reporting criminality. Maybe it's a good idea that we all should have a lawyer, an attorney to consult these things. But in that case, that would also translate our, liability situation to them. Because once they hear about this,
so the comment was made whether that in such situations maybe we should all have attorneys. I will treat that as a question and response. If you come across a situation with which you're uncomfortable and you think that there may be a legal issue, then you should consult with an attorney. I don't think that we all need to run out the door right now and give up our coffee or bathroom break and look for attorneys. Use your judgment. If you come across something that you feel is problematic, and even before you sign the contract, if you have somebody that you can turn to, and I have to move on to one last person because I've already over.
that's actually the question.
Okay, the second one is the question. So.
Everyone is using an iPhone and smartphone, and we have a tremendous amount of sent files and stored files, received files, and attachments from our clients, all kinds of confidentiality agreements included. Everything is there as attachments. Does that mean we have to destroy it immediately?
So the question is, those of us that are using smart devices, and I'm sorry, this is going to be the last question because I see people are justifiably running out. What do we do with these email attachments? Again, I mean, this is a mix of, are you on a secure network? Are you using a Gmail account which is not secure as opposed to a commercial domain, which is with your own domain account? There's no easy answer. Maybe you need to maintain these files. The answer is, be aware of the security protocols you have in place, whether you're on a secure network or not, whether your files are encrypted, and what your service, your email service, and your cloud storage provider allows. That's really more time than I have, so I thank you all. This will be available later. Thank you. And if for whatever reason you want to follow me, contact me, or otherwise say mean things about me, this is the way to find me. Thank you all.